my name's Steph Wilkinson and I'm a legal director in the health litigation team at Hill Dickinson. Today we're talking about documentation, and by the end of the session you should be able to demonstrate and understand the importance of good documentation in your patient's records. So my question to you is, how good is your memory? And the reason I ask this is that a claim can be brought many years after the index event. I have a number of cases I'm dealing with at the moment that date back 20 years ago. So can you remember a consultation you had with a patient last week in terms of details of their presentation, the time you saw them, any colleagues you spoke with, their advice? Did you refer them on? What was your advice? Was there an MDT? Who was there? What was discussed? What was the plan of action? Chances are you won't remember all the specific detail from 1 week ago, and this is not a criticism. You see a lot of patients every day. But again, would you remember details of a patient you saw 1, 2, 5, 20 years ago? In reality, no. Ultimately, you would need to refer to the medical records to obtain the specific detail of that attendance. And you might be thinking, hang on, how can someone bring a claim from 20 years ago? And the answer is that they can in some instances. For instance, if they were a child when the treatment was given, or they lack mental capacity. There is a limitation period of 3 years set down in statute, but judges can and often use their discretion to disapply this limitation period. From our experience, this does often occur. So legalities aside, you could be faced with a claim from 20 years ago, and if this is the case, then you will need detailed medical records to prompt your memory and or completely guide your evidence. And within legal proceedings, the records are the foundation of the evidence that will be produced, including witness statements and expert reports. And claims are regularly settled or lost at court due to inadequate record keeping. When it comes to a judge assessing the witness evidence in court, will they be persuaded by the very specific recollection of the patient, whom for most, the hospital experience has stayed with them and they have relived it for years, or by the usual practice of a professional who can't recall this specific patient? Again, there's no criticism there. You can see, though, it is very easy for a court to prefer the evidence of a claimant, and the only way around this is for there to be good notes. The more detailed and specific the documentation is, then the more persuasive the records become for a judge. Record keeping. Why give good records? There are several reasons for this. As I've just set out in my first slide, to protect yourself, but obviously first and foremost it is to protect your patients. As you will of course appreciate, good detailed records allow for better communication between clinicians and continuity of care. As I mentioned, protect yourselves. The medical records are always the starting point in the investigation of any claim, and so if there are any gaps or inconsistencies, expect the lawyers to start asking questions. There are also 3 lines of accountability, so to your professional body, be it the GMC, NMC, to your employer under your contract of service, and within legal proceedings, so that could be inquests, claims for clinical negligence, court of protection, and NMC, GMC proceedings, and we'll look at those in the next few slides. Regulatory requirements. You'll be aware of your regulatory guidance and requirements for record keeping. Examples from HCPC, NMC, and GMC are all broadly similar. They all set out the need for clear, accurate record keeping, timely record keeping, and you may wish to pause the video just now so you can look at the next 2 slides. I wanted to quickly recap the basics, as these are the issues that do crop up during internal investigations and in relation to inquests and claims quite frequently. So all entries need to be dated and timed using a 24-hour clock and should also be signed. If the name is not legible from the signature, then it would help to print that name. The general trend is obviously towards electronic records, but where handwritten, your writing needs to be legible to everyone else as well as yourself. I've lost count of the number of times I've had a witness tell me they simply don't know what they've written down, so there's no chance for anyone else. If you're, for instance, a junior on a senior ward round and you're making the notes, then please include the senior's name as well as your own. Similarly, if you call, for instance, radiology for a verbal report on imaging or another speciality or hospital for advice, please document the name and role of the person you spoke to, as well as what was discussed. And we'll come on to this in more detail later. Retrospective entries to be avoided if possible, as set out in the regulatory guidance, and entries are to be timely, but we accept sometimes this is unavoidable, for instance, in an emergency. So if you're writing in retrospect, you need to be clear about the time and date of the patient contact, and then the time and the date of the entry being made, and then give the reason for any delay. There is a risk of adverse inference being drawn as to your intentions if someone is looking back at entries and sees retrospective and unexplained entry hours, or even days after the event, and perhaps, for instance, after a complaint has been made. And finally, we all make mistakes. This isn't an issue, but no black pen or crossing out that obliterates what has been written. Just strike through, initial, and carry on. So keeping it professional, it goes without saying, but as a refresher, do not include non-factual, irrelevant throwaway remarks. If you would not be happy to read it to a patient, do not write it. It may or it may not surprise you that I've had cases settled due to inappropriate comments having been made by medical professionals. In the instances I've had, the unprofessional comments were contained in email correspondence that ultimately form part of the complaint file. This is called disclosable evidence when it comes to a claim. So ultimately, the patient and their solicitors were able to see what the medical professional had said about them. Needless to say, it caused professional embarrassment as they were still treating the patient, but also meant that they lost their credibility as a witness for the purpose of the legal claim. And this is evidence that the medical professional could have been cross-examined on in court in front of a judge had the claim proceeded to trial. So as frustrating as a patient may be, always keep it professional. Then moving on, if reference to religion is required, for instance, no blood transfusion, make sure no judgment is cast. Finally, do not attribute blame, be it the patient, a colleague or a clinician at another hospital. The examples shown on the slide here show the difference in just keeping it factual. So this is another key area. Standardised forms are fine, but should still be used with some caution. If a section of form is left blank, the question is whether that is deliberate or whether it was accidentally missed. If it was deliberate, can it be marked, for example, not applicable? Sole reliance on using tick box as a record can sometimes cause difficulty as well. So in this example here, a case we had, there was a wrongful birth claim where mum said she wasn't offered Down syndrome screening and the child was born with Down syndrome. The antenatal clerking was electronic, but we did our research, uncovered the metadata under the old system, and ultimately we located the box that was ticked to say mum had been offered and refused screening. However, mum disputed this. And this went all the way to trial. And rightly or wrongly, the judge sided with mum and said refusal of screening was so unusual that tick box alone was not enough. And they would have expected to have seen documentation of the discussion and mum's refusal. So the point here is the importance of record keeping. It's not simply that there is a record, but it's the quality of that record and the detail of the record as tailored to that particular circumstance. Then regarding guidelines, be it national, manufacturer or trust guidelines, if they haven't been followed, then why not? Guidelines are regularly referred to in legal proceedings to support allegations of negligence. And whilst a failure to follow guidelines does not automatically mean there has been a breach of duty of care, it can make it difficult to defend the claim if the decision made not to follow them is not recorded. I've had a case recently where a clinician could not recall why they didn't follow the NICE guidelines, and it wasn't recorded in the records as to the reason behind their decision not to follow them. And ultimately, our independent expert we instructed could not be sure of their reason why either, and therefore they were critical of their decision making and actions. Lastly, leaflets. So often we see reference being given to a patient, but it would help if you can document which leaflet or version you gave out so that we can obtain a copy later if needed. And with the Trust having a system in place to archive historic leaflets rather than it being updated with no copies kept. Similarly, the same can be said for pathways and protocols. There should be new copies made at the Trust rather than the master copy being written over. Right, so another key area is documenting every contact. It's very important for the medical records to reflect a chronological account of each patient family contact individually. In this example, a doctor was asked to review a sick patient overnight. They attended and asked for tests and observations to be arranged and to contact them with the results. The intention appears to have been to go back when the results were available and document everything in the records then. But when the results were passed on, no second review was carried out and ultimately no entries were made in the records. The potential issues here are that the clinicians during the day could not see clearly what had happened overnight. Assessments they then make may be based on a false understanding of the patient's condition because they lack all the information. And with this particular incident, it involved the assessment of the Paediatric Early Warning System score, and it raised the question of whether the score would have changed if overnight documentation was available. The coroner's comment was that assessments such as PEWS are only as helpful as the documentation is reliable. In the second example here, if it's not written down, it didn't happen. The claim concerned alleged cross-contamination between a tracheostomy and a portacath. The patient developed sepsis and required ICU. The nurses were very well trained in draping the tracheostomy and using ANTT when accessing the port. However, reading the records, these were inconsistent in terms of the notes being kept between the nurses, and in each nurse's entries, sometimes they refer to ANTT and drape, sometimes just one, sometimes just the other, sometimes neither. The claimant's legal team built that because it wasn't written. Sometimes when it wasn't written, it meant it didn't happen. Fortunately, we were able to defend with strong statements from witnesses, but we had to put them to the inconvenience and distress of having to deal with court proceedings. As I mentioned earlier, it's also so important to ensure that when you've spoken with a colleague or another hospital, that you ensure that any verbal discussion is detailed in the records and in enough detail. And that brings us on to our next example. So in this case, the claimant underwent a radical right orchidectomy, but sadly there was evidence of lymphovascular invasion with some small lung metastases, and these were being kept under review. The treating consultant reviewed a subsequent CT scan and discussed it with a radiologist, but just annotated the records as the patient being in complete remission. However, a claim was brought and the clinician considered this conclusion was incorrect given there was an 8mm lung nodule, and they feared that this one annotation affected the management plan of their colleagues, as he was then not referred for a thoracic surgical opinion and he was subsequently discharged. However, he wasn't entirely sure what he had meant by this comment, as this patient wasn't in remission, and the treating clinician reflected and considered the failures in the patient's care stemmed from his expert opinion and this one annotation. If he had recorded a detailed rationale for the conclusion, things may have been different. The patient should have been referred for further treatment, but they were discharged instead. Had a full note of the conversation with the radiologist been included, setting out the size of the lung nodule, then maybe other clinicians would have queried the complete remission comment, or if complete remission comment was fully explained in the notes, it would have given more information and could have led to appropriate referrals being made and the patient staying in the service instead of being discharged. Ultimately, you can never be inside someone's head to know the full details, so the records are where that information should be kept, as detailed as possible to avoid ambiguity and to avoid mistakes being made subsequently. So another area we see is when we get, for instance, blood results. We normally see a list of results with abnormal marked, but normal still included. Radiology will also report no fracture seen, but sometimes when there's a physical examination, we only see the positive or the abnormal response documented. And this becomes an issue when the patient later challenges the examination and says something wasn't asked or wasn't tested. So for example, if there's a clinic attendance, an alleged misdiagnosis, and it all revolves around whether a patient asked about headaches, nil about headaches is recorded. So is that because it wasn't asked or because it was asked, but the patient reported no headaches? We're not suggesting documenting every single thing. You have to use your judgment. But if the absence of a symptom helps inform clinical decision making or a diagnosis, we would suggest you may want to document this. And if the history goes into a lot of detail in the records, it would suggest a thorough examination or assessment took place with a relevant history taken. But if the notes are sparse, then the other side will use this to their advantage to try and persuade a judge that the assessment was inadequate. So key points to note: illegible notes is ineffective communication. Notes need to be understood by others and yourself. Use computerized notes where possible. Use black ink for handwritten notes to minimize fading when photocopying. Avoid writing on the back of forms. This is often lost when photocopying. Use a clear signature and designation or write in capital letters. Do not use initials. With contemporaneous notes, don't leave writing for later, memories fade. A judge is more likely to believe a witness where the records were written immediately. Identify when you are writing retrospectively the date, time written, and date, time of the event. Identify when you are giving approximate timings, as these can be crucial. Ultimately, just to conclude, if you spend a few more minutes adding additional detail to your notes, it could save hours or even weeks of work in the future explaining why you didn't make a detailed note at the time. As it says in the slide, more detailed notes also mean you're less likely to be called as a witness, and if you do attend court, then there'll be less to explain as you can refer to the records. I hope you found this session useful. If there's anything you're unsure of, please feel free to get in touch or visit hilldickinson.com.